Hello, everybody. Welcome to Wednesday's YouTube Live with Ursula and Kerry. Say hi, Kerry.
Hi, Ursula.
Hello. In case anybody's wondering, this is Meatball. It was my son's painting. Moved it into my office, so he works with me. So say hi, Meatball. He doesn't talk much.
Yeah. Hi, Meatball.
All right, you ready to get into it, Kerry?
I am ready. Let's do it.
Let's do it. All right, I'll take the first one. Angel Marrero, greetings. If a mixed urinary urgency claim has severity levels of a 40% each, does the VA adds both, rates them separately, or grants the highest rating of the two? Thank you. I don't know, but what I will say generally is when you have two conditions that have the same symptoms or the same symptoms and level of severity, they're typically going to rate only one, and it's due to VA's pyramiding rules. So you can only be rated for the symptoms one time. That's what I think you're asking, Kerry. Do you see something?
Yeah, I think what's throwing us off, you're saying mixed urinary urgency claims has severity levels of 40% each. I'm not sure where the each is coming from. That's denoting more than one. If you've got, so I'm not sure what you mean there. If you have more than one thing causing a urinary problem, they're still going to rate the urinary problem. For example, if you had MS causing a urinary problem and a real severe lumbar spine paralysis causing a urinary problem, you're not going to get two ratings for the urinary problem. You're just going to get one. Usually going to be rated under avoiding dysfunction or urinary urgency, which is whichever provides the higher rating is how they should do that. But I don't know how you'd come out with more than one rating on that.
Leave it to Kerry to always make sense of what I'm saying.
I'm guessing here. All right.
All right, next.
Timothy, Part 1, Direct Review Option, placed on docket February 28, 2025, based on Barry v. McDonough for SMC half-step increases. Good job on the citation there. At a recent live stream, Carol mentioned that she now receiving decisions back from the RO within 90 days based on this court case compared to months ago. The RO was acting like they never heard of the court case. Should I keep my claim in direct review lane? I already waived my 365-day period. Should I withdraw in writing my 10182 from the BVA and go the supplemental claim lane based on Carol recent update that RO seems to be aware of the case law? It's a good question. This is not something that we can tell you what you should do here. Obviously, you would have the option to withdraw your BVA appeal and go the supplemental claim lane. But here's the thing. I wouldn't, one, if it were me, I would leave the appeal at the board. The direct review lane is still the fastest lane at the board. We are seeing some of those appeals come back somehow within 6 months, a year, usually here lately within a year. And that's kind of rare historically. Hopefully they'll keep that up. There's some other decisions that are not coming back quick, but the more recent direct review lanes do seem to be doing that. The board is going to be more aware of that case law than anybody else, in my opinion. They're lawyers and judges. They should be aware of it. you're not guaranteed in the slightest to get someone at the local level who has heard of Barry v. McDonough. Yeah, it's there's always a lag when the court issues a new decision that affects benefits from the RO figuring out what it is. They have to get guidance on it, and but we still see cases where they've misapplied it or not applied it at all locally, and are still appealing those to the board. Just because the RO is aware of it does not mean at all that they're going to apply it correctly. So I personally, I would leave the case where it's at. Ursula?
I actually very much agree with you. If you're already there and waiting and it's docketed, I think you're going to have a much better chance at the board for them to at least get it right and to possibly assign the correct effective date. I did see somewhere that the board is retroactively applying the Barry case. I saw that in one case that someone shared on one of the bulletins for legal advocates. And I think you're just going to have less fighting at the board. So, yeah, I agree. But it's up to you. Either way, you can do it. Lamel Riddick. I have a queue from 2011 for hypertension and CAD, chronic diseases in service. VA will not act on VSO open BVA hearing requests, but this is AOJ for regional office, so BVA will not rule on this. Help. So it is true that if you filed a Q claim, which doesn't require a form, and you don't get an answer from the regional office and you try to take it to the board is going to say they have no jurisdiction to look at that queue because the AOJ or Office of Original Jurisdiction has to get first bite of that apple before you can take it to the board. Kerry's going to have a much better way to get that claim established, but it's going to be difficult. But they need to establish that claim. What I found is when we just send in memos or something like that, they're not being seen. But one thing we have done is also just filed a supplemental claim form with the queue and say, we're not reopening. This is a queue, but it's on a form that they recognize. And so we sometimes get some traction that way. And you could give that a shot, but I'm going to hand this over to Kerry because he knows the inner workings a little better than I do.
Well, I mean, I don't know about that, but I'm kind of guessing here on the question. I don't really know if you're saying you're having problems getting a BVA hearing, but Ursula's right. You definitely cannot send this to the Board of Veterans Appeals if the regional office has not made a decision, unless you are declaring a CUE in a board decision. That's different. That's there's a code for that. It's Title 38 U.S. Code 7111, where you're declaring a CUE against a previous board decision. Those have to be filed directly with the board because the RO simply doesn't have legal jurisdiction to overturn a previous board decision. But apart from that, which is kind of rare, you have to file that at the RO, and the VA has lost their damn minds when it comes to CUEs. They just don't recognize them anymore. It's like the first line raters and the intake folks who are supposed to establish that claim. Man, it just goes right past them. We have to follow up with just about everyone to get them to establish the claim as a motion for revision based on clear and unmistakable error. So that you may be some, and I don't know if that's what you're saying there, where say VA will not act on VSO open BVA hearing. That like you're kind of confusing me with that language. But if that's the case, I agree with Ursula. You may need to file it on a supplemental claim form. You may need to do it more than once. Your VSO may have to, get up out of their chair and contact somebody in VA to force them to establish that claim, if that's what's going on. But yeah, it's all over the map when it comes to these people trying to figure out what a Q is.
It would be so helpful, don't you agree, if they would give us a form for a Q?
Ironically, it's funny you mentioned that. I've had a couple of meetings with folks in central office on this subject. It got where I got so fed up with it that I went to the undersecretary and I said, just establish a damn form for Q. Now here's the problem. I'm not technically for that because I'm afraid, Qs are rare. Most people who think a Q is not a Q, if that makes sense. And what you don't want is to clog up the system with a bunch of people filing for a Q because there's a form for it when they're all going to get denied, or most of them are going to get denied because they're not legitimate CUEs. So but at the same time, the way it's going now, we might as well have a form because they're just not getting it. And they did indicate that a form, they can't tell me, they won't tell me because they have to post that in the Federal Register and there's rules against that. But somebody did tell me, yeah, you might be getting a form here soon for a Q. Now that was prior to the election and all that. So, who knows? I'll believe it when I see it. But yeah, at this point, that would help.
Good luck, Mr. Riddick.
Yeah. All right. Next one, Mecabe, if I'm pronouncing that right. Part 1, thanks for all you do. Submitted an HLR for GERD. Initial claim was from 2022, was denied. Then submitted a supplemental, denied, and now received a decision letter from the HLR. Part 2, I've been evaluated for GERD using the new criteria. I wasn't supposed to be evaluated with, wasn't I supposed to be evaluated with both the old and the new rating criteria since the claim was before the change? Okay, part 3, this is what's on the decision letter. VAMC does not appear to have been completed using the new examination format needed to address the new rating criteria for GERD. They identified the DTA, but what to evaluate me again with the newer criteria? What's next? All right, it threw me off there. But to answer your question, basically, yes. If your claim was pending prior to the new criteria coming into effect, they're supposed to look at both the old and the new and apply the criteria most favorable. Now, that could be the new in some circumstances. It could be the old in some circumstances. If they simply have told you, we're not applying this one set of criteria because we didn't do the right DBQ, well, that's kind of a problem on them. And I would think, yeah, an HLR would not hesitate to send that back to get another exam with the proper DBQ. So if they did that and you're still in that not remand, but duty to assist era phase, then what's next is they're probably going to get another DBQ and issue another rating decision. That's what they should be doing. You have anything on that, Ursula?
Nope, that's everything. All right, Chris, part 1 of 2. After 24 years, I got my 100% permanent and total on my own without help. Congratulations. It's amazing. But the effective date is off by 2 years. I filed a CAR with a lawyer, came back with a reduced rating on my skin disorder from 60% to 10% and want another CMP exam on my already 50% rated knee. My knee CMP exam measured flexion and short interview by a nurse practitioner. If I lose this one, I will lose my 100% rating. So, okay. So I'm not sure what the question is, but I can talk generally on reductions that I can do. So, I mean, if you were 100% and you were going for an earlier effective date, I'm not entirely sure why VA even orders exams for an earlier effective date, because getting an exam now to, look at something from 3-4 years ago doesn't make any sense to me, but they do it. And, in a case like this, they can't just reduce you, especially if you're going to lose something like 100% rating. There's certain criteria that they have to meet. It has to, if you've had the condition for more than, if you're more than 5 years, it has to be under the ordinary conditions of life. Like, there's all these other things that they have to prove. They can't just take away your 100% rating based on one CMP exam. So I would definitely, if they're proposed to reduce, ask for a hearing, explain to them that things are not better, things are the same. And as long as that's the truth, and just have a conference, a predetermination hearing with those people and let them know. And maybe you can stop the reduction from going through. That it's a pain. It's a lot of work. And that sucks pretty much.
Yeah, I mean, it's not enough there for us to address why they're reducing the skin from 60 to 10. But I mean, typically with that level of a reduction, almost all the time we see something wrong with that kind of reduction. I would look at on what evidence did they rate rated at 60%? On what evidence are they reducing it? Is it just two different VA exams that both reported the same thing, vastly different? It could be lots of reasons why that reduction there. But on the knee, and I might be reading into this, so if I am, I apologize. You said you want another CMP on your already service 50% rated knee. I don't know if that means you're going for an increase in the knee. Here's the thing: if you're rated 50% for a knee,
he said he was
just
just
me.
going for earlier effective date. I think he was just going for.
That may be. And like I said, I might be misreading it. But if you're going for an increased rating on the knee, there's not many places a knee rated 50% can go but down. So I'd be careful with that. I mean, it can't. A knee can go to 60 if there's a knee replacement and it's seriously affecting stuff above the knee and it's constant pain. Most of the time you can't even get 50 for a knee because you're exceeding the amputation rate, which is 40% for an amputation below the knee. But yeah, you got to focus on that reduction. Odds are there's something wrong with that. Wish I could say more, but I don't have enough info.
Yeah.
All right, Sissy Morgan, how long would you make your argument at the BVA direct lane? I find that about 25 pages would do.
Sometimes you've sent it. Well, go ahead.
Okay, I'm kidding. I mean, length does not make, how long your argument is does not make it better or worse. That depends on how many issues you have, how complicated they are. I've done arguments that are 30 pages long, and trust me, that's not fun. I would much prefer a concise argument that talks only about the facts pertinent to the case and the law pertinent to the case. And a lot of times when you do just that, it does not have to turn out very long. Some people will judge their representatives, especially if it's a private firm, how long they make it. It's not necessary. Some of you are better. I like the saying, "I would have written less if I had more time," and that's kind of true. So don't worry about how long it is. Worry about get the right facts in there, and how does the law apply to those facts? And 90% of the time, you're good with that.
I agree. Travis, I'm currently rated 0% for shin splints. About to put in for an increase later this year, but now VA docs think it's compartment syndrome and not shin splints. Would I need to file a new claim? No, I don't think so, because it's the same thing. It's the same symptoms that you were going for, and I don't really know how to explain it, but I do know it's like the same thing. It's like if you file for something based on the symptoms and you get rated for it, but then you are later diagnosed with another condition that is still giving those same symptoms, it's still going to be rated that same way. So I don't think you need to file a new claim. VA can recategorize that claim. So, if you go in and compartment syndrome is going to give you a higher rating. I'm not sure what a compartment syndrome is, but let's say there was its own rating criteria and it was more favorable, they can rate you under that and then just recategorize the shin splints. So no, I don't think you need to file a new claim for it.
Yeah, and there's questions on the end of most DBQs, and they ask whether if whatever the examiner diagnosed is a new diagnosis, and if so, is that a progression of the previous diagnosis, a correction of the previous diagnosis? And there's case law to help you out there too. You're not the medical expert. What you know is that your legs hurt. You filed a claim for it. They realize that was started in the service. If it turns out now that it's a different diagnosis, that could end up helping you. But I wouldn't file a new claim for it.
Yeah. And even to take it a little further, so as Kerry was talking, like let's say you're service connected for shin splints, but then you get this compartment syndrome and they're saying that's not service connected. Like they know where that started from. And if they can't tell the difference between the shin splints and the compartment syndrome, as far as the symptomology goes, there's a case out there that says that they have to rate it as the service connected condition as well. So you have a lot of things kind of helping you there, but no new claim.
All right. PhD, FYI. Recently had PTSD subclaim, CMP exam, and psychologist said she cannot mark suicidal ideation unless patient experienced it within the last 3 to 4 months. Does that sound right? I got 70% anyway. That does not sound right. I don't know that there's some medical protocol that I'm unaware of about what is a suicidal ideation with respect to when the ideation occurred. One thing I would say about it in respect to claims, though, is if your claim's been pending a year and you had suicidal ideation 6 months ago, then you had suicidal ideation during the pendency of your claim, and that's important. I don't care what that examiner says. And so what you may need to do if they, one, you got the 70%, so that's good. I mean, get 100%, sometimes suicidal ideation by itself will simply not get you 100%, unless it's pretty severe. So you may not need to do anything. But if they hadn't given you that rating, or if you're not pleased with that rating, you can always write a lay statement saying, look, this is what I told the examiner. This is what they told me. They did not report it on the exam. And just set the record straight. it, they're not going to just redo another decision because of that. But at least you have something in the record that you're going to be able to use for arguments if you need to. That's about it.
Yep. John J. Do IU veterans, so individually unemployable rated veterans, have to request permanent and total, or will VA upgrade after so many years automatically? The veteran has only been rated for 1 year. So it depends. So I've seen TDIU come through with permanent and total status, which is the Chapter 35 benefit at the outset. But even if you're given permanent and total status with the TDIU, that doesn't mean that they're not going to check your income and make sure that you're still not working. They're still going to cross-check with Social Security. It just means that they're not going to open you up for other exams. But I have not seen where a TDIU veteran is just TDIU and then without prompting, VA makes it permanent and total. I've never seen them spontaneously do that. So, I mean, you could argue for permanent and total, but usually if you get unemployability, they're usually giving you Chapter 35 benefits, which is permanent and total.
Yeah, that's what I was going to add is before you assume you're not, maybe you know for a fact you're not, but you might be. Most of the time, when people get rated for TDIU, they get rated with no future exams, unless you had other issues out there pending for some reason. If you do, I would probably cancel them, unless they're going to affect the effective date or whatever. But even the regs for TDIU talk about the fact that they award it when you're considered permanent, totally disabled from an employment standpoint. So it's not something we generally see with future exams. So, if you're young and it's a closed period of unemployability or something like that, I suppose, we've seen them do it differently, but make sure you're not already TDIU or permanent total, because you could be.
Yeah, if you're receiving Chapter 35 benefits, that's permanent and total. Dependents education assistance, if that ever came through on your rating decision, or if you look on your rating code sheet under ancillary decisions, you'll see Chapter 35. That means that you are permanent and total.
Now, what you also see some rare, it's not very often, look at your future exam date. If it says none, as long as you don't have any other thing pending, and it says none, and you don't have Chapter 35, then odds are they just forgot to put Chapter 35 on the paper. So that happens, but it doesn't happen very much. PhD, 1 of 4. I had initial PTSD non-combat exam with, I'm guessing, decision letter, February 21st, 2024. Was granted 30% service connection with correct effective date of ITF date of May 5th, 23. On February 4th, 2025, I appealed within the 1-year deadline, continuously pursued, and got increased to 70%, but April 15th, 2025, decision letter put effective date as exam date. Yeah, well, sounds like VA. March 1st, 2025. 425 decision letter also states, since the evidence doesn't support a higher evaluation from the initial claim, increased service connection for PTSD should be granted from the date of facts found on the date of the VA exam, i.e. March 1st, 2025. Should an original May 23 ITF date prevail? HLR CAR, what does CAR stand for? I don't know that CAR would be the best option there. I mean, that's certainly an option. CAR stands for Claims Accuracy Review. It's just an HLR on with a fancy name. They're supposed to be used when there's just an absolute dumbass mistake, excuse my French, that anybody could point to. There, you're talking something the VA does all the time, and that's you had a 30%, and let's just say hypothetically that your exam on which, or the medical evidence on which they gave you the 30% supported the 30% and not higher, and you appeal and they gave you a new exam. And then that exam shows you rateable at 70%. And that was, let's just say that was the first evidence in the record that shows you were rateable at 70%. And I'm just playing devil's advocate here for a second, because that's usually not how it is. But if the scenario was like that, then VA can legally say on a facts-bound basis, you did not show an increase in your disability until the day of that exam. Therefore, we're giving you the 70% from that date. Where they go wrong, it's like 100 places where they go wrong, and I can't name them all. But let's say the Board of Veterans Appeals granted service connection, and there wasn't any VA exam in the record. Maybe there's medical evidence diagnosing the condition, and I mean, just hypothetically, they didn't examine you, or maybe the exam was, 10 years old, or whatever they just didn't go out and get a recent medical exam and just rated you at 30%. You come back and appeal, and the HLR reviewer looks and goes, yeah, they should have examined you after the board granted service connection. And so they go out and get an exam, and that exam shows 70%. And then they rate 70% effective day of that exam because they claim, well, that's when facts found. No, that's not true. That's their misapplication of a facts found rating effective date. It should go back to the original claim there, because they're basically punishing you for their shoddy development in the first place. It doesn't mean your condition simply wasn't as severe as previously shown. Either way it goes, I would probably appeal that. I think whether you go to the board with it or I probably would, simply because they've got a better, in my experience, they've got a better track record of applying the effective dates correctly. These first line raters absolutely do not. Now, you could try HLR if you haven't already done that. Well, I guess you haven't, since that was part of your question. So yeah, you could do HLR, before you try the board. Hopefully I answered that question. I know I got.
You did. You did. I would personally go higher level review and ask for a conference. The things that you're going to point out is the claim stream. So show your procedural history, intent to file, did this, supplemental claim, to show continuous pursuit. But then it's not just continuous pursuit that you have to look at. You also are going to have to pull out things from the record from before when they granted that shows a 70% evaluation. So you're going to want to go in and say, on this date, this statement said this. On this date, these were the symptoms that I had. This is what the doctor said. Show the severity of it. And those are the two things that you need to get that that rating further back. Another thing is, it's going to be really important to classify your issue. A lot of people will just kind of go, oh, I want an increased rating for my mental health. At this point, that's not actually what you're asking for. At this point, you are asking for an initial rating higher than the 30%. So make sure that you're being specific on what your issue is, because you don't want to have them just go, well, no, 70% is right where you are. You're looking specifically for that period. So I hope that helps. But yeah, I wouldn't go CAR either. Ejo, 1 of 5. Thanks for all that you do.
Are you guys like I was wondering if you guys are like in a competition with each other to keep adding parts to the questions.
Maybe. Let's see what we can do here. All right, 1 of 5. Thank you for all that you do. Listen to your first time asking a question. Listen for years first time asking a question. Got about 20 years ago, VA screwed me. Now getting back in the fight for justice. Trying for a mental health claim. Never tried to get one. Looking for a path of least resistance. You all in Combat Craig taught me that. It's easier to claim mental health secondary to my service-connected migraines at 0%, putting in for an increase to 50, or service-connected migraines and service-connected back at 10%, putting in for an increase. Also have radiculopathy now. Or trying to go primary since there are many things during my active duty that caused anxiety, depression, etc. Primary or secondary are both true. What is the path of least resistance since I have been out for so long? If secondary is, I would like to go secondary service-connected migraines and back since they both affect my mental health. But is it better to do secondary to just one of them and not confuse VA? Why not do both? I don't know why you have to do just one. I think path of least resistance, I don't know that there is one. It depends on what your medical records say and, whether or not your service-connected conditions are causing and worsening your mental health, or whether or not the record shows like the changes in service and things like that. I don't know without looking at the file what the best course of action is. So, I think it depends, but you can put both forward and see what happens. And VA has to develop for both of those things. You can say, look, I've got in-service things directly related, but I also have it based on my service-connected conditions, and it's both. So, Kerry, that's really just a strategy thing. What would you do?
I would do both because if VA there's a number of issues here. If VA finds a way to deny your claim and you only go one, and to go back and then re-raise the other, when you had a chance to raise it from the beginning, it's just better to raise it from the beginning. If they don't address one method and grant service connection, so then no harm, no foul. If they don't address one method and deny service connection, you've already started the process to show they erred in not developing the case under one of the theories of entitlement you filed for. So there's benefits to doing it both. As far as doing it for the back or the migraines, that's no question there. I would absolutely do it for both. All right. Put it this way. If you have service connection for your lumbar spine and it's so painful that you're getting depressed and anxious, and you have the same thing in your cervical spine, would you just say it's related to one? No, I'd say it's related to both. If some bit of pain is going to cause a mental health condition, then more pain is going to cause it all the worse. So if you have two different things that could affect your mental health, put them both on there. I probably would, make my primary, just based on what you're saying. Now, I could change my mind if I looked in your file, but I probably would make the secondary claims primary. But they really don't take a precedence inside VA. VA is supposed to look at both paths. But I say that only because if you never had any complaints while in the service, and it's been a long time since you've been out, and you're not talking about like a combat related PTSD, they might look for something specific in your service records to link the now depression to. And that may be difficult for some claims. So if you have a service-connected disability that's causing it, that might be a little bit easier. Now, if you got treated in the service or you have some kind of markers, indicators in the service that you can link that to, that could easily change my opinion there. But that's kind of what I would say. All right, Steve Alfonso, SRA guy. I'm not sure what that is. ECG showed mild concentric LVH, which is left ventricular hypertrophy. CMP examiner checkbox, no indication of cardiac hypertrophy, rated 10% instead of 30. What steps? If that's your first rating, I would simply ask for an HLR with a conference, point out the fact that you have diagnostic evidence of an enlarged heart, which is what the hypertrophy is. That should get you a 30%. I've seen that several times. That's exactly what I would do in that situation. These examiners just don't get me started. So yes.
That's a whole nother podcast.
Yeah.
Yeah. It that tracks. That's par for the course. File an appeal.
What's that?
I said this. What I'm reading here is par for the course. It tracks.
Yeah.
Just file an appeal.
Yeah, that one's pretty straightforward.
Yep. Crystal Carruthers. If denied PTSD increased to 100%, but decision letter states hubby had 6 out of 7 100% criteria symptoms and DBQ check deficiencies in most areas, what to include reference in higher level review? Okay. So if I am reading this correctly, you've got a claim in right now for an increased rating of PTSD, and you're trying to get that rating to 100. Okay, so let's go back to the DBQ real quick. When you look at the occupational and social limitations, deficiencies in most areas is indicative of a 70% rating. Now, that is not the only thing they should be taking into account when doing the ratings. It should be that occupational and social areas, but then also the symptomology. I'm not sure, when you're saying they had 6 out of the 7 100% criteria, if that's true and a lot of that stuff was listed in the rating decision, that's what you want to point out. Like, these are the symptoms, these are severe symptoms, and these are more indicative of a 100% rating. And that's kind of what you want to point out is the symptoms. And if there's any kind of information in the file that shows total occupational impairment. So if he is unable to work, unable to, socialize with people, kind of stuck in the house, those types of things where completely isolated, that would be indicative of total occupational impairment. So point out those types of symptoms by going through the record. That's what I would say.
Yeah, I think I know where you're getting the 6 out of 7. You have to understand how VA uses those DBQs for mental health. There's one set of questions that are diagnostic. There's another set of questions that are symptomatic. What I find a lot of times when you start breaking them apart is the diagnostic portion. It looks like you're just gone. And the symptomatic portion, you might have a little depression and anxiety. So, and it raises the question there that why are you more severe for diagnostic purposes, but not very severe for symptomatic purposes? It doesn't make sense. But I can tell you right now, that's not what they use to rate the case. There's another section in there. If you sound like you've done your homework, go back and look at the mental health rating criteria. Look at the first sentence of each, 0, 10, 30, 50, 70, 100 criteria. There's another section on that mental health that coincides with those sentences, where you say deficiencies in most areas. That's 70%. There's a sentence under the 70% criteria. This is the first section of everything else is kind of qualifiers of how you get to that 70%, that most areas. When they mark that box, that's what they're going to rate it as. Not 99 times out of 100. All right. So it's not that, and the raters aren't going to look any further than that. They're going to go straight to that box. What did they mark there? They marked the one consistent with 70%. That's usually what they're going to rate, and they're not going to go further. I mean, don't expect them to analyze the evidence. I mean, come on. That's
No, they literally check that
God
box.
forbid.
Yeah. So they just look at that box pretty much. And a lot of the times we see like reduced reliability, but you go look at the symptoms or you read some of the things that are in there and you're like, that is not reduced reliability. That is much more severe than that. So
yeah. I make joke about, analyze, because they used to have to analyze the evidence before those DBQs. The CMP examiner might write a narrative as to how the vet's actually really doing from a mental health standpoint. You had to read that narrative and analyze it. Now that, you got decisions kind of all over the board, but made them think.
all right, next one.
All right, Cynthia, am I showing? Sorry. I'm dyslexic today. I'm sorry. I am showing symptoms of possible carpal tunnel and ulcer nerve syndrome. I don't know what ulcer nerve syndrome is.
Maybe ulnar. Maybe it's supposed to be ulnar.
That may be, yeah. Do I wait to see what my upcoming diagnostic tests show, or do I file a claim now? I have SC back problems too. All right, so I'm trying to weigh my answer here. Okay, it's hard to file a claim if you don't have a diagnosis. If you're having symptoms right now, VA is going to want to know what the diagnosis is. Okay, so they may come back and say, well, what's the diagnosis? They could kick the claim back for that. At the same time, you could, if you think it's carpal tunnel, you could list it as carpal tunnel. They're going to examine you and they're going to say, yeah or no, you do or don't have carpal tunnel syndrome. They may or may not be right about that. Same thing with the ulnar nerve syndrome. But I see a lot of questions like this. We get a lot from our clients. Maybe they got out of service, 40 years ago, and hey, I've got arthritis in my knee now. When, should I file a claim now or later? And my first question is usually, all right, you have arthritis in your knee. You got out of service 40 years ago. How do we hook that knee to service? Okay, because the answer is usually very vague. Like we don't have evidence hooking it to service. And people get in a habit of filing a claim for everything they're diagnosed with. All I'm suggesting is before you do that, how do you relate it back to service? Maybe it's this service-connected back problems, and maybe that's what you're alluding to. Typically, carpal tunnel is not going to be caused by a back problem. Now, radiculopathy may be caused by the back problem. If it's in the cervical spine, if it's in the lumbar spine, and your problem is in your arms, those are not going to correlate out with each other. So all I'm saying is, before you go just filing the claim, think about how you're going to get service connection for it, because that's obviously what you need at the end of the day. I hope I'm making sense there. I'm not sounding too crass.
No, I second that. We do get a lot of people that just want to file for everything. There needs to be a way to link it back to your service. But I will add, you could always file an intent to file now and wait until you have your diagnostic tests and then file, as long as it's within a year. So
that's good advice.
Yeah. Get that intent to file in. Nathan Jar. All right. Finally got service connected for sleep apnea secondary to rhinitis burn pits after 3 years of appeals. Thanks for the advice and help of videos, HMB. Don't give up, people. You guys listen to Nathan. Don't give up. Keep going. Keep going. All right. Did that count as mine
Burn pits, a guy after my own heart there. That's I have a little history.
All right, I'll take this one since that one wasn't really a question. And we are just going to do 2 more questions, so this one and the next one. All right, Airborne Trooper. If I apply for aid in attendance, will that trigger a new C&P exam? Currently 100% SMCS for PTSD and TBI rolled together, plus migraines, tinnitus, GERD, plantar fasciitis. Okay. Yes, it will probably trigger a new exam for aid in attendance even if you've submitted a VA form 2680, which is the housebound aid in attendance form, you will probably get an aid in attendance exam. You may get, I've seen it where they just do the aid in attendance and not all of the conditions, but I've also seen them do new CMPs for the PTSD and TBI and things like that. So yes, it will trigger an exam. I don't know what extent of exams it's going to trigger. Kerry?
I don't think I can add to that. I just say, be careful. You've already got SMCS. Do you need help feeding yourself? Not cooking for yourself, but feeding yourself. Do you need help dressing yourself? Do you need help bathing yourself? Do you need help going to the bathroom by yourself? Because that's what they're going to be looking for. Or the alternative, do you need help keeping yourself free of harm? And a lot of people go out there and go, well, I'll occasionally leave a burner on. That's usually not going to cut it. Okay. And so just think about that. You've got a good rating, and that's why I say that. I'd much rather keep a good rating than be fighting a reduction. But if there's no doubt about it, you need help with that stuff. Ursula's right. Sometimes you'll just get the A&A exam, and sometimes you may get other ones.
All right, last question.
All right, Mark had one of 2. Good morning. Regarding HLRs, if denial found to be erroneous, what happens from there? Do they send you back for a CMP exam even after multiple exams for the same condition? It becomes supplemental. Next part. So does that mean I have to go through the same thing as if I had followed through with my initial CMP exams, etc., or can they process it as an error and correct it to finalize the claim? I really don't have enough there to answer that. Nate, go back to the first part. So if a denial is found to be erroneous, see, I don't know what you mean by erroneous. That could mean a lot of things. Maybe they denied it without doing the proper development, and the HLR sends it back to get that development done. Like you say, do they send it back for a CMP exam? They do that a lot. Actually. And yes, you may have to go to multiple exams. Yes, it may be exams that you've already had. I know that's frustrating, but we see it all the time. We get asked all the time, well, do I have to go to this exam? No, you don't have to go. But understand, if you're going to an exam and then getting a rating, that rating is done by the supplemental claim team, not the HLR that sent it back. And they're going to deny that claim if you don't show up for that exam. So you just have to play their game sometimes. All right, Nate, go to the next part. So I'm not sure again what you mean when you say, does that mean I have to go through the same thing as if I followed through with initially? I don't know if you're saying there's something you didn't follow through with, or am I just misreading that? Uh, yeah, you may have to repeat the whole process, but I don't know if that's exactly what you're asking. I think so, but Ursula, am I misinterpreting that? You think?
I mean, no, I think we don't know what the error was. And so it's hard to answer this question. If it's being sent back for a DTA error, yeah, you may have to go through the whole process, but higher level reviewers do actually have the authority to overturn or change a supplemental claim lane. So let's say you get denied for PTSD and they say it's because you don't have a diagnosis and you've already done all the exams. The higher level review person can grant service connection and rate it at that point. So both things can happen. It just depends on what's going on with your claim. A lot of times a previous denial is erroneous. That's why we appeal. Or the rating is erroneous. So without knowing more, it's difficult to answer, but both of the things that you've laid out here can happen on higher level review. That's what I would say.
Yeah. And Ursula, can we answer two short questions?
Yes.
All right. So and Nate, you don't have to put them up. I see them on the side. Willpower, you got my attention with the name Willpower. He asked YouTube claims attorneys and claims doctors claim. YouTube claims attorneys and claims doctors claim OSA, obstructive sleep apnea, can be secondary to tinnitus. Is there any truth to this? All right. Yes, there's some truth to that, but please, for the love of God, take that with a grain of salt. Those are hard claims. I personally, and you may have heard it even on this website, I would do everything in my power to find another way to link obstructive sleep apnea to service before I use tinnitus. Okay, not saying it cannot happen. It's just exceptionally difficult. If you've got a better way, use the better way. And there's another question is James Laufenberg, how do I calculate the 160% rating? All right, I just wanted to answer that. There's no such thing as a 160% rating. I think what you mean is the 100 plus 60. I think I could be wrong there. You're talking about special monthly compensation at the S rate or the housebound rate. For that, you need a single 100% rating, and then you need either a single or combined separate rating of 60%. The 60 doesn't have to be a single 60. It could be, a couple of 20s, a few 10s, as long as they combine to 60. But the 100% criteria has to be a single 100% rating. And that doesn't mean your house
based on one condition,
right? Or TDIU on ones like say TDIU just on mental health, and then you have a heart condition at 60%. That would get you the same thing. So anyway, just wanted to answer that real fast. It's kind of easy.
One way that you can check your ratings is Hill and Ponton has a calculator. I'll have Nate or Benji link it somewhere. And you can go there and, take your 100% disability and move it to the side. And then you can add in your other disabilities and see if those equal up to 60%. You can also play with it and see what you would need to do in order to get you to that 60% once you've taken your 100% and moved it to the side. All right. Well, are we done here, Kerry?
I think so.
We're done here. Okay. It was great to see you guys. Meatball says bye. Hi, Meatball. We'll see you guys.
Do you see Blaze?
No, we can't see him.
Oh, I thought you were talking to my dog. He's behind.
No, I was talking to Meatball, the cow. All right, bye guys. You'll see someone from the firm next week. Maybe it's us, maybe it's not, but have a wonderful rest of the week and a great weekend.
All right. See you guys.